Justice Gorsuch. Justice Kavanaugh.
In your brief, you want us to go further than what Justice Gorsuch suggested. As I understood his question to you, it was, should we just say mere knowledge is not enough to show purpose, and you said, and send it back, and you said that could be okay, but obviously in your brief you wanted us to go further in that and spell out what could show purpose. So what's the advantage of going further versus saying less?
Well, the advantage, I guess, is the same one that the court perceived in Twitter, whereas the court held that the case should have been dismissed on the pleadings. And the idea was a suit in which all you could show was that the defendant had provided kind of generic services to the general public, and that some people had misused it, and the defendant had failed to make that stop. That wasn't enough even to get past 12b-6. And so I think there would be an advantage to making clear that in the future, not only should the ISPs win at the end of the day, but they shouldn't be subject to the burdens of litigation if that's all you have.
When I asked Mr. Rosenkranz to spell out what could be done to show purpose, do you agree with his answer on that?
I mean, I guess the thing I would emphasize, and I'm sorry I don't remember the precise details of his answer, are I would emphasize the differences between targeted assistance and provision of general purpose technology. That is, there are
what do you mean by targeted assistance?
There are an infinite number of situations in which somebody may provide assistance to one person that he isn't providing to anyone else.
Such as?
Such as in the dance hall cases, the proprietor of the dance hall was hiring a band to play, and the band was...
What would be the equivalent here?
I mean, I don't think there would be an ISP equivalent unless, as Mr. Rosenkranz suggested, the Cox provided some special service that would only be useful for infringers. In that case, you could say that this is targeted at infringement. The point about the targeting is often when you do something for one person that you don't do for anyone else, and you know that person will use the assistance to commit a legal violation, it's reasonable to infer that's why you provided the assistance. But when you are providing internet service to every member of the public who will pay the fee, infringers and non-infringers alike, there's no basis for that inference.
On the patent law analogy, Mr. Clement in his brief relies heavily on the Henry case from 1912 and says that it shows that selling a good with the expectation that it would be used to infringe supports contributory liability. So that's a case heavily relied on. I want to get your response to that.
I guess I'd make two different points about that. The first is, as Cox's reply brief points out, if you look back at the trial court opinion in Henry, the court's opinion recites that the ink that was being sold was a specially suited ink, specially developed for a mimeograph of this type. And the trial court opinion also reflects that the defendant went to the offices of the purchaser and told her, I'll sell you this ink for your mimeograph, but pour it into an old jar that was provided to you by the patent holder and throw my jar away. And so the word expectation originally came from the trial court's opinion. That was the certified facts. And so I think Henry on its facts was a good case for secondary liability. The other thing I would say is, even if you read Henry as standing for a broader proposition, namely that if you sell a multi-purpose product to a particular customer that you know will use it to infringe, you can be held liable, that's been superseded by the Patent Act, in which Congress codified other rules of contributory infringement in patent case, but not that one.
Thank you.
Thank you.